Hi, I'm Luke Nichols with the law firm of Nichols & Green here in Northern Virginia, and if you've been on YouTube recently, you might have seen some of the videos of people going through DUI checkpoints or being stopped by officers as part of a DUI investigation, and the driver's videotapes the interaction, and he basically hands this flyer to the officer with his license and registration and refuses to answer any questions. This is part of the Fair DUI project, or the Fair DUI Flyer project, where some activists and YouTubers down in Florida created this flyer, and the flyer says, "I remain silent, no searches, I want my lawyer, put the ticket under my windshield wipers, I have to display my license and registration, I don't have to hand it to you," and all this kind of information about their rights and what they will and will not do is put on the paper, and they just lower their window enough to slip it out with their license and registration, or they just smack it up against their driver's side window so the officer can read it, and they simply show them the license and registration through the window but refuse to lower the window or refuse to answer any questions or anything like that. Well, while this may or may not work down in Florida, each state has different laws, and what might be okay in Florida could very well be illegal here in Virginia. So what I'm going to do is talk to you about your rights during a DUI stop and your rights during a checkpoint stop. And we're going to talk about how some of the things about these videos are right and some of the things are wrong. Is it legal to audio record or tape record an interaction between a police officer? Now, the answer is generally yes. In Virginia, we have what we call a one-party consent rule. So as long as one party to a conversation is okay with being recorded, then it's okay to record the conversation, even without the other party's knowledge. So for instance, if a police officer approaches your window and he has a tape recorder on, or a body camera, or a cruiser camera, that's okay. He doesn't have to tell you you're being recorded, and he doesn't have to get your permission to record you. He can just do it because he's a party to the conversation and he has consented to the recording. So on the flip side, if you record a conversation between you and a police officer, that's okay, even if the police officer doesn't know about it. So as long as one party to the conversation consents to being recorded, that's a legal recording in Virginia. Now, what you have to be careful is if you're a passenger or you're a bystander and there's a police officer and another person having a conversation and you audio record them, that may or may not fall under that exception. Depends on whether or not it's a private conversation or it's something that's out in the public, and it depends on whether at least one of those parties consents to being audio recorded. But at any rate, so generally speaking, you can record, or audio or video, record a conversation between you and a police officer, and that's perfectly legal. Another question I see, or another misconception I often see on some of these YouTube videos, is people challenging the constitutionality of checkpoints. As long as they're done right, they are constitutionally valid. The U.S. Supreme Court and the Virginia courts have both upheld the legality of certain types of DUI checkpoints and other types of checkpoints as well. In order for it to be a constitutionally valid checkpoint, a couple things need to happen though. First off, the officers on the scene cannot have discretion on who to pull over. So if they're randomly pulling over whoever they feel like it, that's not constitutionally valid. But if there's a plan in place, saying like we're going to pull over every third car, or we're going to pull over every car, then that's not subject to racial biases or gut feelings, and it's less prone to abuse. So the first rule is there has to be a predetermined way of deciding who gets pulled over and who doesn't. Now, if you do something illegal while you're in the checkpoint area and the officers see it, they can pull you over just like they can any other day. So if you try to run past the DUI checkpoint or you make an illegal U-turn, they can pull you over even if you're not the assigned car that was supposed to be pulled over. But as long as they have a pre-approved plan that dictates who gets pulled over and the officers on the scene don't get to decide that issue, it's generally considered, or it's one of the ways that distinguish a valid versus an invalid checkpoint. Another issue is whether the intrusion on the innocent public is great or not. There's this balancing test between how important is it to catch these types of criminals versus how much are we willing to put out the public. Okay, so how long are cars stuck in traffic because of this DUI checkpoint? So if they set up a DUI checkpoint at like an event center, which they often do in Prince William County, then the question becomes, okay, are they gumming up traffic? And if you're gumming up traffic too much, it becomes a constitutionally invalid DUI checkpoint. Because instead of people just being able to go through the checkpoint in a matter of seconds, they're stuck, 15, 30 minutes in traffic. Suddenly, what the police are doing, it's causing too much burden on the public to justify the benefits. Another issue is the level of intrusiveness. So for instance, if you get picked to be inspected at a checkpoint, what does that entail? How invasive is it? If it's pretty much somebody shining a flashlight in your face and saying, hey, have you had anything to drink tonight? If not, move along. Generally that's considered constitutionally valid. If it turns into like a 15-minute discussion and where they want you to get out of the car and do all these tests, that's too much. Now, the exception to that is if during that brief, uninvasive first contact, the officer detects evidence of DUI, he can then pull you out and do a more invasive inspection. So what it is they've got to have a pre-assigned plan to determine who gets pulled over. It needs to be a minimum amount of burden on the innocent public, and two, the level of intrusion when you're picked to be inspected has to be low, unless investigation reveals evidence that justifies a more invasive inspection. So as long as all those things are done right, it's considered a legal, constitutionally valid DUI checkpoint. If it's not, there's problems. And this is where a good attorney can really help you out. With DUI checkpoints, there's a lot of evidence that has to be brought in for the government to be able to prove that what they did was constitutionally valid. Because the burden is on the government to prove that their checkpoint is valid. And if they can't meet that burden, then the checkpoint's illegal, the stop's illegal, and any evidence that stems from that gets thrown out of court. So generally that means you win the DUI case. Can the police order you to roll down your window? Now, in these videos, you see people saying, the officer saying, hey, please roll down your window, and they're like, nope, I can hear you just fine. Or they just slap up the flyer and they refuse to talk. Nowhere in Virginia law does it say you have to roll down your window. It does say that you have to carry with you your license and registration, and if an officer asks you for it, you have to show them your license and registration. However, the problem is that an officer, for pretty much any reason, can ask you to exit your vehicle. There's a Supreme Court case where an officer was in the habit of every time he did a traffic stop, he would pull the person out of the car and he would perform the stop outside the vehicle with the person there standing on the side of the road. And that was just his habit. He did that with every single driver on every single stop. And his justification for doing so was that he felt it was safer, because he could see what the people were doing and where their hands were. So the officer was pretty much pulling every single person out of their car, regardless of what they did, with no justification other than he felt it was safer for him. The Supreme Court of the United States said that was okay. An officer could do that. And so here in Virginia, we have no laws that preempt that Supreme Court ruling. So if an officer wants to pull you out of the car for pretty much any reason, whether it's his own personal safety, or he wants to be able to smell you, or he wants to be able to tell whether you've been drinking, or he can't hear you well enough, he can pull you out of the car. And it seems to me that there isn't any clear law saying he can't do that. So if you want to not lower your window, you can go ahead and do that. If you want to slip flyers and registration cards and licenses through a crack in the window, or press them up against the glass, that's fine. But if the officer in turn wants to pull you out of the car and do the rest of the stop with you standing on the side of the road, it seems that he's able to do that too. Is it legal for the officers to pull me out of the car, even if I've not done anything wrong? Generally speaking, the answer is yes. The Supreme Court of the United States has ruled that an officer can pull a person out of the car on a very de minimis, very minimal excuses. So if the officer just likes to pull everyone out of the car because he feels it's safer for him, he can do that. So officer safety is a broad blanket of excuses that allows an officer to pull a person out. So if the officer says, "Oh, I feel it was safer for me," generally speaking, that's a constitutionally valid reason to pull someone out of the car. Additionally, if there's any evidence that they've been drinking, or they smell the odor of alcohol, or your eyes look a little bloodshot, a lot of judges accept that as well as an excuse to pull the person out of the car. There's only a handful of judges who take exception with officers pulling people out of the cars for no good reason. Generally speaking, in Virginia, the law is an officer can pull you out of the car for any reason. Now, the question then becomes, well, what if I don't want to leave the car? Now, theoretically speaking, if you just go completely dead weight, and the officer says, "Get out of the car," and you sit there and you do not resist him at all, or take any proactive movements to resist him physically pulling you out of the car, it's a little bit of a gray area, and I think most defense attorneys would tell you that that's okay and that's legal. However, it's dancing a very fine line. There have been plenty of people who have gone that route, who have gone dead weight and let the officer pull them out of the car, and they've been charged with resisting arrest. Or the more likely scenario is what happens is they physically pull you out of the car, maybe they smash your window first, and then when they throw you down on the ground, they're not so gentle, and when you start saying, "Ow, it hurts," your handcuffs are too tight, and you start wiggling, then they claim you're resisting arrest, and if you thrash around too much, then and you put them in fear of an unfriendly contact, then it's assault on a police officer. So what you see is these situations where people refuse to get out of the car, they often escalate into more serious charges, and it gets ugly quickly. So under Virginia law, the safest interpretation is that an officer can pull you out anytime they want, and if they order you to do so, the best thing to do is to do so without talking. You do have a right to remain silent, so you can exit the car without talking. And that's the best thing to do. If you go online and look up the Fair DUI Flyer project and a lot of these videos associated with it, a common thread is that you don't have to sign the summons. Now, this is not true in the state of Virginia. You don't have to sign the summons, but trust me, you want to sign the summons. What happens is whenever you're charged with an offense, whether it's a traffic ticket or a serious DUI, and the officer writes a summons, he's essentially arrested you. He's charged you with the offense. And your bail, your bond, is your signature, your promise to appear in court. That's what your signature means on a summons. When you sign that, you're promising to appear in court on that charge at the specific time written on the summons. If you do not sign, that means you're not promising to appear in court. And the law in Virginia is pretty clear. If a person refuses to appear in court, or they give an officer reason to believe that they won't appear in court, the officer instead can handcuff them, take them in the cop car, drive them to the magistrate's office at the jail, and let the magistrate deal with it. And then the magistrate can either hold you in jail without bond, make you pay money to post bond, or after a nice cop ride in the back of the car and a talk with the magistrate, after a couple hours, maybe they'll convince you to sign your summons then and then let you go. Needless to say, signing a summons is a good thing. That's how you have your freedom pending trial without having to pay money. So if you don't want to sign the summons, you can do that, but you're going to go see a magistrate. You're going to piss off the cop. They're not going to be happy with you, and the judge is going to think you're a little bit of a jerk. So you're going to make a lot of enemies. You're going to end up taking a ride downtown, and it's not going to help your case one bit. So if any time in Virginia someone gives you a summons, take the summons, sign it. Just don't cause any fuss. That stuff you see online about summons doesn't apply in Virginia. You want to sign the summons here in Virginia. Often when you see these YouTube videos about people standing up to the police and exercising their rights, there's a lot of question about First Amendment. Can you criticize the police? Generally people think that they have carte blanche to criticize the police and say whatever they want. And this isn't completely true. Generally speaking, yes, you can criticize the police, you can be rude, you can be offensive to a point, and that's legal. However, If you start threatening the police officers, or your use of profanity and the aggressiveness in what you're saying is to the point where it's likely to provoke violence, then you've broken the law here in Virginia. If you threaten a police officer, that's obstruction of justice. If you use language that is designed to provoke violence, that is disorderly conduct. So those are two criminal charges you can be charged with if you push the envelope of what's allowed under the First Amendment. So we have a constitutionally given right to remain silent. I suggest you use it. If you are ever in a situation, you can criticize the police officer if you so feel that it's an important thing to do. You can do that, but whether you can do something and whether you should do something are two different things. So you have a right to remain silent. The best thing to do is to exercise that right and remain silent. And we're talking about this in the context of a DUI case. I'll tell you, I've seen many cases where over-the-top nasty behavior has been used as evidence of drunkenness. Because we all know that one guy who gets drunk and he just turns into a loud-mouthed jerk. And so when you get these DUIs where the people are just saying horrible things, they're just like, oh, that guy is just, it sounds like he's drunk. That comes across as if you're drunk. Okay? If you just sit there quietly, they can't use that against you. If you start railing and ranting about your rights, this and screw you and this, that, you know, it's going to sound like you're drunk. And the officer's going to testify he was slurring his words, using profanity, being over-the-top aggressive. They're not going to like you. It's going to sound like your inhibitions were down due to intoxication. So just exercise your right to remain silent. The small handheld breathalyzer device that officers use to test your breath on the side of the road is called a preliminary breath test, or PBT. This device is a completely voluntary test. Under Virginia law, you do not have to take the preliminary breath test. This is different than the evidentiary testing device at the police station. After you're arrested and you're taken to a police station or a hospital, and they ask you to blow into a machine or draw blood, if you've been lawfully arrested of DUI, and then afterwards they ask you to take a breath test or a blood test, that's not voluntary. That's a totally different thing. But on the side of the road, before you're arrested, the small portable breathalyzer device is a PBT, and that is voluntary. Virginia law says you do not have to take that device. Interestingly enough, the same law that says you do not have to take a preliminary breath device also says that you can demand a preliminary breath device if one is available. So you can, and if you get pulled over and an officer starts investigating you for DUI, you can say, I'm done talking to you, I'm done doing your tests, I'm not going to talk to you anymore, give me a PBT right now. I want to do a breath test right now. And if that officer has access to one, he has to offer it to you under Virginia law. So if you're stone cold sober and have absolutely no alcohol in your system and you just want to prove it and get on your way and have this officer stop interrogating you, you can demand a preliminary breath test. But if you've had any alcohol in your system, do not take a preliminary breath test device. The law says that you can arrest and even convict somebody for DUI if they're under the legal limit. So even if you think you're good and you're under the legal limit, don't take the preliminary breath test. The law says that that device is used simply to tell whether there's alcohol in somebody's system. And if it detects alcohol in your system, that can be used to justify the arrest. So just because you think you might blow under the limit doesn't guarantee that you would be released. So if you have any doubts that you might have alcohol in your system, do not take the preliminary breath test. If you know you're stone cold sober and you just want to be have the officer to leave you alone and let you go on your way, you want to convince him that you're stone cold sober, you can demand a preliminary breath test device. But remember, there's a difference between the preliminary breath test device and the mandatory evidentiary testing device. Okay? Here's the way you tell the difference between the two. The PBT is given to you on the side of the road. The mandatory device is done at the police station. Okay? The PBT, the voluntary device, is small, portable, it's handheld. The evidentiary testing device is a large boxy machine with a big tube that comes out the side and has a keyboard and a printer attached to it. It's not portable. The voluntary device, the PBT, is done before you're arrested for DUI. The evidentiary testing device, the mandatory one, is given to you after you're arrested for DUI. So that's the difference between the mandatory one and the voluntary one. And you'll see very often people agree to take the voluntary one and then refuse to take the mandatory one, and they've shot themselves in both feet. A lot of people ask me whether or not they should take the blood or breath test after they're arrested for DUI. And the fact is that doing so is required by law in Virginia, and refusing to take the blood test or refusing to take the breath test after you've been lawfully arrested for DUI is another charge you can get, and it comes with some pretty serious penalties. The first time you've ever been charged with a refusal, if you have no prior refusals, no prior DUIs, it's a 12-month mandatory loss of license with no restricted license at all. You will not be driving for 1 year in the state of Virginia. If you have prior refusals or prior DUIs, you can go to jail and receive fines for refusing to submit to a blood or breath test. So it's a pretty serious offense, and it can have real ramifications on your life and on your DUI case as well. So it's really important, though, to understand the difference between mandatory blood testing and breath testing and non-mandatory blood testing or breath testing, because it's not always clear. So the preliminary breath test, or the PBT, that's offered you on the side of the road, that's voluntary. You can refuse that, and you should refuse it in most situations. The evidentiary testing device at the police station after you're arrested is mandatory. So here's a couple steps to tell the difference between mandatory breath testing and voluntary breath testing. Okay? Voluntary breath testing is with a PBT. It's oftentimes a little handheld device, about this big. Okay? The officer pulls it out of his trunk or pocket and has you blow into it on the side of the road. The mandatory device is large and boxy. It has a big tube that comes out the side. It has a keyboard and a printer. It's not portable at all. The voluntary device is given to you on the side of the road. The mandatory breath device is given to you at the police station. The voluntary device is given to you before you're arrested for DUI. It's something the officer uses in deciding whether or not to arrest you. The evidentiary testing device, the mandatory device, is done after you've been arrested for DUI. So if it's on the side of the road with a small device before you've been arrested, voluntary, don't take it. If it's a large boxy device at the police station after you've been arrested, you have to take that or you're going to be punished. A lot of people come into my office after they've been arrested for DUI and they say, should I have taken the field sobriety test? And the answer is always no. By field sobriety test, I'm talking about the stand on one leg and the walk the line and the ABCs and following the little pen with your eyes and touching your fingers to your thumb and counting backwards. All those little exercises and things that the officer has you do on the side of the road. Never take those. Never take those. Okay, just don't take the field sobriety tests, period. Under Virginia law, you do not have to take those. An officer cannot force you to take the field sobriety tests in Virginia. And they're not great tests, and they're only as good as the officer who gives them. There's a lot of reasons why you shouldn't take those tests. You have nothing to gain from it, frankly, and a lot to lose. A lot of people can't take those tests sober. They don't understand what the test is, and pretty much all it is the officer looking for things that you've done wrong. Okay, so you don't have to take the test. There's no reason to take the test. If you know you're stone cold sober and you've had nothing to drink, don't take the test, demand a PBT instead. You have an absolute right to demand a breath test on the side of the road if one is available. That takes a few seconds. Doing all the field sobriety tests takes about 15 minutes. So if you know you're stone cold sober, you've had absolutely nothing to drink, and you think that you want to prove your innocence, don't do it with the field sobriety test. Demand a preliminary breath test. That'll take just a few seconds instead of you sitting on the side of the road doing this for 15 minutes. Okay? So, at any rate, don't take the field sobriety test. There's no reason to. A lot of people will ask me, well, if I refuse the field sobriety test, won't the officer know I'm guilty or think I'm guilty? Doesn't that look bad? The truth of the matter is your refusal to take the field sobriety test cannot be used as evidence of intoxication. It can only be used as evidence to justify arresting you. So if your defense attorney challenges the legality of the arrest, then the fact you refuse the field sobriety test can come in only if there's other signs of intoxication. So an officer, basically, they can't use your refusal to take the field sobriety test against you unless you've challenged the legitimacy of the arrest and there's other signs of intoxication. So if you're just sitting on the side of the road, you get pulled over, you're like, I'm just not taking the test, that cannot be used against you. Okay? And even if you have other signs of impairment, if you refuse to take the test, that can only be used against you if you're challenging the legitimacy of the arrest. So there's very, very little to lose about refusing the field sobriety test. A lot of people will ask, well, won't the officer think I'm guilty if I refuse? Just remember, the officer already thinks you're guilty. That's why they pulled you out of the car and is making you do all these silly tests on the side of the road in the dead of winter. It's because they already think you're guilty. So don't worry about what the officer thinks. Worry about whether or not you're going to get convicted of DUI. A lot of things you see on the internet about the Fair DUI Flyer and about standing up for your rights shows people demanding their lawyer. Like, I want to talk to my lawyer. You do have a right to an attorney under the U.S. Constitution, but it's a very, very specific right that only applies in certain situations. So for instance, there's two separate rights to an attorney. You have a right to have an attorney present during a trial, okay? And you have a right to a court-appointed attorney if you're poor enough and you're facing jail time in the state of Virginia. But we're talking about your right to have an attorney while being interrogated. That's a completely different right than your right to have an attorney during a trial. Your right to have an attorney during your interrogation kicks in if you're in police custody and you're being interrogated. Those are the two things that have to happen before your Miranda rights, or your, which includes your right to an attorney, kick in. Being in police custody means being arrested or being in a very restrictive form of custody. So just being pulled over on the side of the road generally isn't police custody. If you're pulled out of your car, you're handcuffed and thrown in the back of a cop car, that's a little bit closer to police custody. It's a little bit of a gray area where exactly police custody kicks in, but when you get arrested, it's almost always kicked in by that point. And an interrogation is when any time an officer asks you a question. This is a very broad definition. So if an officer asks you pretty much any question about the criminal charges they're investigating, that's an interrogation. So the officer asks you, how much have you had to drink tonight? That's an interrogation. If the officer asks you, well, what were you drinking? Or how do you feel? That's an interrogation. Even if he's asking it in a very friendly, open, honest way, not, shining bright lights in your eyes and threatening. Interrogation is any time they ask you questions, the purpose of which is to investigate you. So if you're in police custody and an officer asks you questions, then you have a right to an attorney. However, in order for the police to be forced to leave you alone, you have to specifically ask for your attorney. And you can't just say, I want an attorney. You have to be very specific. You have to make it clear, unambiguous, that you want an attorney during the interrogation, not your trial. So if somebody says, shouldn't I have an attorney, or I'd be more comfortable if I had an attorney, it's a gray area, and lots of times it doesn't apply. Your rights haven't kicked in. You have to specifically say, I want an attorney during this interrogation and any future interrogations. You have to be exceptionally specific. Some of the case law in this regard is not particularly favorable to defendants. So you have to be extremely specific, and you have to realize that that only protects you during custodial interrogations. Because of this, officers, smart officers, don't do any interrogations after they take you in custody. They do your interrogations before they take you in custody. So if I pulled you over on the side of the road and I'm just talking to you, either through the window or when we're doing the field sobriety test, that's not an in custodial interrogation. So it's not until you've been arrested or handcuffed and put in the cruiser, then that kicks in. So the officers, the good ones, ask their questions before they get to that point, so that your constitutional right to have an attorney present hasn't kicked in yet. However, if you ever want to make it clear that you don't want them to talk to you, you don't want to answer any more questions, you don't want to be interrogated, and you're in police custody, ask specifically for an attorney during the interrogation. Say, I want an attorney present while I'm being interrogated. And if you say that specifically and unambiguously, then the police officers have to cease and desist all custodial interrogations. It's a powerful tool, but you have to use it right and you have to use it specifically. So merely saying, I want a lawyer isn't good enough. You have to say, I want a lawyer while I'm being interrogated in police custody. And then you also have to realize that this right does not kick in until you're both in custody and you're being interrogated. If you're just in custody, you don't have a right to have a lawyer present. If you're being interrogated but you're not in custody, you don't have a right to have a lawyer present. You can remain silent. You can always remain silent. But your right to have an attorney present hasn't kicked in yet. So remember, it has to be a custodial interrogation, and you have to specifically demand to have an attorney present during the interrogation. And if you do that, then they have to shut down the custodial interrogation. One question I get a lot about checkpoints is, do you have to drive through them? What if you don't want to go through a DUI checkpoint? It's completely legal to circumvent a DUI checkpoint as long as you obey all the laws and traffic laws. So for instance, if you're driving down the road and you see a checkpoint up ahead, and you go, I don't want to do that, and so you make a lawful U-turn or you turn the car and go around in a different way, that's completely legal and the officers can't stop you. However, if you have burned out tag lights, if you do some really crazy suspicious driving that gives the officers reasonable articulable suspicion to pull you over, then they can go ahead and stop you for doing whatever you were doing. So circumventing the checkpoint in and of itself is not illegal. It's not grounds for pulling somebody over. Doing it in an overly suspicious way, doing it in a way that violates laws, that is grounds to pull somebody over. So you don't have to go through the checkpoint, but you do have to drive your car in a normal, safe manner. One of the tricks the officers use in Northern Virginia to prevent people from doing this is they'll go and put up signs that say like construction zone ahead or something, and so people see all the cones and they see the gummed up traffic, and it doesn't scare them off. They say, oh, it's just construction. But then when they get up closer, oh, it's a DUI checkpoint, and then it's too late to turn around. You're already in the cones and there's nowhere to turn. So at any rate, that's some of the little tricks of the trade they use. A lot of people ask me whether they can choose to take a blood test or a breath test. Many years ago in Virginia, it was the law that a driver who was arrested for DUI had a right to a blood or breath test, and that they could choose which one they wanted. And this caused the defense attorneys to have a lot of fun with that. So the legislature changed the law, and that is no longer the law in Virginia. Currently, the law is that you do not have a right to demand a breath or blood test after you've been arrested, and you don't get to choose which one you get. The law states that the officer can demand you take a breath test anytime you've been lawfully arrested for DUI, with a few exceptions. And if the breath test is unavailable, if they suspect you of using drugs, or if you're physically unable to take the breath test, then they can have you draw blood instead. So the officer can demand you take a breath test, or under some conditions a blood test, but you cannot demand one. So if you get arrested for DUI and no tests are available, and you start demanding, I want a blood test, I want a breath test, that you don't get one. There's no right to it. And you don't get to pick which test you get, blood or breath. So if an officer says, please take this breath test, and you say, no, I want blood. No, that's a refusal. You can't do that. That will get you in more trouble. You have to take the breath test unless you're physically unable, or unless the officer tells you to do a blood test under certain circumstances. A lot of people ask me about searches, not just in DUI cases, but all types of cases. Searches are really important, and they're really invasive, and people find them really offensive. So even if it's not part of their criminal case, if they got searched, they often ask me about it. So here's your rights to, here's what you should know about searches. Searches and seizures are regulated under the Fourth Amendment to the U.S. Constitution. A seizure is any time the government restricts your freedom, either your freedom to move, your freedom to possess something, and a search is, a search. You look through something. Police officers can search you or something you own anytime you give them permission. They have a search warrant. They have probable cause to believe that they're going to find something illegal. If you're being arrested, if it's an emergency, and if they're impounding your property. Those are the general rules about searches. Now, there's a lot of exceptions, but the takeaway point you should remember is that any search is legal if you allow it, if you give them permission. So an officer can walk up off the street with no evidence, no reason at all, just go, "Hey buddy, how you doing? Can I search you?" You say, "Okay." He can do that. Even though he had no lawful right to demand it, he can ask it. And it can be really intimidating when police officers ask to search you. Okay? So you have to know your rights and you have to stand your ground quite firmly. Now, if an officer is overly coercive, that can cause problems. It's not a true consent if the officer oversteps certain bounds, but generally speaking, it has to be pretty coercive before the judges will throw out consent as being non-voluntary, as the product of something coercive. So if a police officer ever asks you whether they can search you or your car or your things, the answer is no. Don't do it. There's no really good reason to do it. You're giving up your rights and you're going to get nothing in exchange for it. Officers will often say, "Well, it'll be better for you if you do this," or "We'll go easy on you if you just let us search your car." And often these are pie crust promises that don't mean anything. The officer's idea of helping you out is arresting you and then maybe giving you a summons instead of taking you to jail. And that's not a very good trade for your constitutional rights. So if an officer ever asks whether you can have consent to search something, the answer is no. Well, hopefully this video was helpful. Hopefully it's answered some of the questions you have about DUI investigations and DUI checklists. Thank you for watching, and if you have any questions, you can go to our website, nicholsgreen.com. And if you have a criminal charge in Northern Virginia and would like a free consultation, you can call at 703-383-9222 and speak with myself and my law partner, and we'd be happy to talk with you about your case.